Now then, let's take up Abel Estrada Jr. Mr. Estrada, you'll need to start your audio and your video.
Yeah.
Okay, all right. We are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant.
You can hear it. Before Estrada even speaks, the court is sifting through months of missed appearances, refilings, and what sounds like a whole mess of, I filed it, no you didn't. Classic sovereign citizen-style confusion, except Estrada isn't hostile. Just, stubbornly confident.
The defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of cost and fines had to be paid before or at the time of the appeal. We had a peer review February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond.
Here's the key issue. Estrada was found guilty, but instead of just paying $158, he tried to appeal without paying the required bond. And if there's one thing courts hate, it's when someone tries to outsmart procedure. Clip 3. You can feel the judge's frustration here. Estrada keeps saying he filed everything correctly, yet there's no proof. This is the eternal clash between, I said I did it, versus, show me the paperwork. And guess who always wins in court? The paperwork.
To date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification, should have received notification of the docketing, should have received notification of any motion that he filed to waive for the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature several times. I may be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number, so I could not enforce.
And just like that, boom. Turns out the paperwork was filed, it just hadn't hit their system yet. The judge basically has to eat his own skepticism. You can hear the shift from, I don't believe you, to, okay, fair enough.
Of 158, the court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table. Okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case.
Even when he acknowledges it, the judge still delivers a warning with dry humor, calling Estrada's license plate a piece of cardboard you bought from someone. That's judge speak for, I think you're full of it, but let's see what the appeals court says.
Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that
Earned some respect. Instead of steamrolling Estrada, he's trying to protect him. He's literally saying, look, even though you're technically in appeal, the DMV might still think you're suspended, and they might arrest you anyway. That's not mockery, that's a warning from someone who's seen this happen before.
Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't override them.
Estrada asks the judge to call the DMV for him, and the judge basically says, buddy, I agree with you, but Kansas bureaucracy doesn't.
You might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct if it needs correct it eventually, but it could cause some headache for both you and
that's the real reality of the justice system. Sometimes, even when you're right on paper, you still lose in practice unless you chase it down yourself.
Okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is this something that I can call you back so that you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature.